Hello, and welcome to this edition of the GLG Legal Property Law Reports. My name's Peter Lee. I'm a Special Counsel here at GLG Legal, being an accredited specialist in property law. Today I want to talk about real estate contracts, and we'll start with the expression unconditional contracts. Any of those of us involved in property will have heard often the expression that someone has an unconditional contract. In general terms, we as lawyers don't really like this expression. It's generally taken to mean that there's a real estate contract which is certainly going to go to completion. To real estate agents, it generally means that the contract is no longer subject to finance, not subject to due diligence or any other special conditions, and hence is going to complete sometime in the next month or two. But contracts for real estate will come in many shapes and sizes. Probably the one thing we can say for sure is that the contract must be in writing, signed by the party who's to be bound by it, that is the seller. This is very old law, dating back to the Statute of Frauds in England back in the 17th century, and is currently enshrined in our Property Law Act, including the most recent amendment of the Property Law Act in Sections 6 and 7. But even in that case, there can be exceptions, such as contracts enforceable at equity, often on the basis of part performance, part payment, or other activities. Be mindful also that we now have email and text, and the court makes it clear that emails and texts can be writing. So you may have a situation where a seller finds themselves bound to a contract to sell their land because they responded to someone's inquiry or email saying, yes, I accept your proposal, or words to that effect. So be very careful if those situations might arise. But I'm going to focus on the most common forms of real estate contracts in Queensland, and that is the Real Estate Institute of Queensland real estate contracts. I have two of them here. The first is the residential REIQ real estate contract for residential land. You'll find that most commonly used with suburban real estate agents for sale of house and land. By contrast, there's the REIQ contract for commercial land and buildings. This relates to commercial buildings such as warehouses, offices, shops, and so forth. These are more commonly encountered by those professionals in the property industry and the property development industry. The terms and conditions of these two contracts are largely identical. The commercial contracts go into more detail as to more commercial matters. But the significant factor of both is that they contain 12 standard conditions, which are broken down into 6 or 8 subconditions. So it's a bit of a nonsense to say that you can ever have an unconditional contract, because there are approximately 48 provisions in each of these contracts that take effect from the time of signing and remain in force until the date of completion. And all of them give the buyer certain rights and the seller certain rights in the event of non-compliance. One of the things I want to do today is investigate in more detail those terms and conditions and what effect they might have on your property purchases and sales. Now, to properly understand this discussion, I need to take you into something of an investigation of the law of contract. There's a general misconception that a contract is breached and therefore the other side can terminate the contract. It's black and white. Well, I'm afraid it's not. With a contract, there are essential terms, there are intermediate terms, and there are warranties. It's only the breach of an essential term or a substantial intermediate term which entitles the other party to terminate the contract. Generally, those parties can terminate the contract and sue for damages. However, if there's breach of an unimportant term or a breach of a warranty, that will rarely give rise to a right to termination. The only remedy in those circumstances is to push on with the contract and claim damages, either before or after settlement. This is a very important distinction for young lawyers to understand, because far too often I've seen novice lawyers threaten not to settle on the basis of some trivial non-compliance, which in fact exposes that party to breach of contract if they were to follow through in that course. So be very careful before you consider not proceeding with a contract on the basis of some fairly unimportant breach. The contract gives us some assistance in this regard by defining what are essential terms and what are warranties. Most importantly, failure to pay a deposit is a breach of an essential term. That is, failure to pay the full deposit on time as required. In fact, under the standard REIQ contract, it's required to be paid immediately upon signing the contract, and many people fail to do this. Technically, the seller could terminate the contract immediately, forfeit the deposit if it does get paid, or sue for the balance deposit. That would be a very unfortunate situation. Often these contracts are amended at the time of preparation to allow for a day or two for the payment of the deposit, and that makes sense. Now, I'm going to deal with the individual clauses in the contract, and I'll start with the residential contract. Before I get to the standard conditions, there are about 4 pages what we call the items schedule, and they are the blanks that get filled in by the agent normally before the contract is signed. That will include the name of the seller, the name of the buyer, the price, the deposit, the settlement date. It will also include a provision for whether the contract is subject to finance. Most residential contracts it is. Now, the finance provision has 3 boxes: the finance amount, the financier, and the finance date. The courts have held that the failure to complete all 3 boxes renders the finance clause inoperative. So be very careful that your agent completes all of the boxes before the buyer signs the contract. Again, agents very rarely pay adequate attention to this, and they will often put sufficient to complete as the finance amount. The financier, any bank, the finance date is normally 14 days after the date of the contract, or possibly 21 days. That's what we find in 90% of contracts. But that's not really using the contract to its greatest advantage. And if the seller were to look at that contract, they have no idea how much the buyer needs for finance, whether he has any prospect of getting it, and he won't have an unconditional contract for at least 14 days. It's prudent for a seller to insist that the finance amount be completed. So if I'm selling a property for $900,000 and the buyer is borrowing $500,000, I can be reasonably confident that they will get that loan. But if I'm selling for $900,000 and I don't know it, but the buyer is seeking to borrow $925,000 to pay the stamp duty as well, we know he has 0 chance of getting that finance. So there's no point in signing the contract. But very little attention is paid to this. While I'm on the subject of the finance clause, buyers should bear in mind that they cannot rely on that finance clause for not proceeding if they haven't made a reasonable and genuine effort to get finance in accordance with the terms of the contract. It's no good coming back to your lawyer the day before finance and say, I spoke to the broker, he didn't think we had any chance, so I didn't bother applying. In those circumstances, your contract is no longer subject to finance, and if the seller is a tough person, he may well hold you in default of the contract. So please pay attention to the finance clause. The other clause commonly completed there is the building and pest clause. Normally that's 14 days and is uncontentious. The important part of the contract, there are 2 sections which again don't get enough attention. The description of the property, which deals with the land, the address, the real property description, the title reference, the area, the present use, and the local government. Now, of those items, the area and the present use are very, very important, because if the seller gets it wrong, they can be sued for compensation, or the buyer may get a right to exit the contract. Always check the area against the real property plan to make sure you've got it exactly right. For example, if you say that the area is 1,000 square metres and you're selling land at New Farm for $10 million, that will be an enormous compensation if you're 50 square metres out. So please avoid that. The present use is often completed by agents to state the obvious: house, shop, etc. But it's actually more technical than that, and I'll get to that in more detail as we go through the standard conditions. The other very important part of this contract is the matters affecting the property. From a buyer's perspective, we want to see the word nil. What this means is that the buyer must accept the title with those noted encumbrances on the title. Now, a buyer doesn't want any encumbrances on the title. If there's an easement, that's an impediment. If there's a lease, that's probably an impediment. And at law, the buyer can refuse to accept such an impediment unless it is written here in the contract. So from a seller's point of view, make sure you get this right, and from a buyer's point of view, make sure it says nil. And if it says anything, be very careful to ensure you understand what it says before signing the contract. For a buyer, do not accept the lazy expression subject to encumbrances noted on title, even if the title's attached. I've seen this done, I've seen contracts signed, and in reality the buyer must accept the property with the seller's mortgage on it, which is obviously nobody's intention, but that's what would happen if the contract was strictly enforced on its terms. Again, don't be lazy. Ensure the word nil is written in there, or if there are encumbrances such as an easement or a lease, write in the dealing number and the type of transaction that it is. The other important aspect here is the settlement date. Normally settlement is 30 days on a residential contract, sometimes a little longer, and normally 42 days or 60 days on a commercial contract. Time is of the essence of the contract in Queensland. That means that you must settle on the due date. It is completely unacceptable to turn up the following day with the right amount of money, and the seller has every right to refuse your money and forfeit your deposit. That's what time of the essence means. One of the problems we have in Queensland is that we are the only jurisdiction to have time of the essence. New South Wales and Victoria don't have it. So with the centralisation of national banking practices, your banks simply don't understand the concept of time of the essence. They may not have your documents ready unless you really push them, and it's no defence in Queensland to say, well, my bank in Melbourne didn't give me the finance documents until the day after settlement was due. It is your problem, and you have to make sure that your bank understands the significance of that. Having said that, the most recent edition of the standard REIQ contract has softened the time of the essence provision somewhat. Clause 6.2 now allows an extension of 5 business days by either party unilaterally giving notice to the other side. While I don't disagree with this in concept, we need to be very careful in practical terms. If you're acting for a seller, this is an unattractive provision. If nothing else, you must add an additional a special condition stating that in these circumstances the buyer must pay interest as per standard clause 9.9 of the contract. I say this because clause 6.2 that they've inserted doesn't make any comment about interest and does not require any payment of interest. So I'm finding it is almost standard practice for buyers to adopt that provision and push the settlement out by a full week without paying any interest in the interim. While it might not sound like much, the interest on a $1.5 million contract can amount to $400 a day, which is a very substantial amount. It will dwarf the legal fees that you're being charged over a period of a week, I can assure you of that. Now back to the standard conditions. Clause 2 deals with the purchase price, which is obviously very important and dear to the hearts of all the parties. Clause 2.2 deals with the deposit. It provides that the deposit can be invested if either party insists upon it, but it does in those circumstances require provision of tax file numbers and various other things. It is not commonly adopted unless it's a very substantial deposit and it's a long-term settlement, say 90 days or longer. Clause 2.4 deals with the entitlement to the deposit, and generally it provides that if the deposit is returned to the buyer for no default by the buyer, that is because finance failed or something else, then interest will accrue to the buyer. If on the other hand it goes to the seller because of the buyer's default, then the interest will go to the seller. Again, it is possible to change those provisions by special conditions. Clause 2.5 deals with payment of the balance purchase price. That's all fairly standard procedure and fairly well recognised by solicitors and conveyancers. There's been a minor hiccup recently with the introduction of capital gains tax withholding taxes, and there's a requirement on the sellers to advise whether they must remit capital gains tax or provide a capital gains tax-free certificate, or more correctly a tax residency certificate, in which case no tax is payable. Again, the procedures for that are relatively well known to conveyancers. Clause 2.6 deals with adjustments. This is an area where complications can arise, particularly where one party is reluctant and the seller, for example, is trying to specifically enforce their contract. A buyer who cannot complete because they don't have the money or don't want to complete will often complicate things by arguing interminably about the adjustments, the rates adjustments, land tax adjustments and everything else. It's important for practicing lawyers and for sellers not to get caught up into that rhetoric. If there is a settlement date, it's important that we ensure that our seller clients comply with that obligation, work out what we believe are the settlement figures, send it to the buyers and demand the buyers complete. We must then tender for settlement. This is the only way we can protect the seller's position. I can assure you that when we go to a barrister after a failed settlement, the first question he will ask me is, did you tender for settlement? And if my answer is no, he'll send me back to do it again. If my answer is yes, then we can move forward with the process of default, specific performance, or whatever else might be the case. The reason I raise it here in adjustments is because we as sellers' lawyers must not get ourselves drawn into the adjustment argument or debate, or allow us to get distracted from setting things up to ensure that our seller clients can insist that settlement occur at the scheduled time and that we tender everything we need to do. We can only do what we can do, and that is tender everything and be ready to go. If the buyer can't complete, we have preserved our seller clients' rights then to forfeit the deposit, seek specific performance or whatever else might be needed. I drum this home to all of my practicing lawyers, and at GLG Legal we will ensure that the seller's position is perfectly well preserved in all these circumstances. In parallel with that, we may well be having discussions about extensions, extending time, or various other adjustments, but they are in parallel and they must not derail the primary arrangements for settlement, which is our primary concern. I mentioned that clause 3 and 4 deal with finance and building and pests, so there's not much more that we need to talk about there. Clause 5 deals with arrangements at settlement, again handing over the keys, handing over the money. It should all be fairly procedural, where we have a buyer who wants to buy and a seller who wants to sell, and a conveyancer who knows how to do it. Generally, we don't have any problems with that. It is important to always bear in mind that entitlement to interest. Be aware that there is a default interest rate issued by the Queensland Law Society from time to time that applies to these contracts. It is currently 10.6%. So on a $1.5 million contract, that's $150,000 per annum, $3,000 a week. It's very worthwhile paying attention to it. The really important parts of this contract are the ones that give the buyers rights to object. Now, the process is that the buyer will sign the contract and then conduct a series of searches. If they find anything wrong with the property, then they will object to that. That doesn't necessarily mean that they can terminate the contract. Sometimes it does, sometimes it doesn't. How do we ascertain that? Because it's written in the contract itself. So clause 7 deals with matters that are affecting the property. And under 7.4, there's a series of seller's warranties. So the seller warrants that that there's no outstanding notice from the council with respect to the building. The seller's not received any communication or notices on other parts of the contract. There are no threatened or claimed proceedings by any court order for execution against the property, and so forth. There's quite a list of those things. Now, even though they call them seller's warranties, bearing in mind what I said earlier, they are in fact conditions, because if any of them are breached, the buyer has the right to terminate the contract, and that's what they will do. They must give notice prior to the date of settlement and terminate the contract. Clause 7.5 deals with survey and mistake. The buyer is entitled to conduct a survey. If they find an error or misdescription with the boundaries of the property or the area of the property, then they can make a claim with respect to that. If it's an immaterial error or misdescription, their only right is the right to compensation. If it's a material error, that is a major error, they have the right to termination. Now, you might think it's a simple case of simply putting a line through these clauses and deleting them, which would extinguish the buyer's right to make such objections and claims. But that's not correct. It's far too simplistic approach. The REIQ contract here is actually reflecting what the common law tells us. So even if these clauses were not in the contract, the buyer would have that right with respect to survey, errors and misdescriptions. So simply crossing it out won't achieve your seller's purpose if you want to make it a truly unconditional contract. What you need is a degree of surgical precision to change that contract in such a way that suits your seller's needs. And that might be, for example, changing the clause to define what would be a material error, an error of greater than 10%, or including a provision that the buyer has had ample opportunity to conduct surveys and inspections and the contract is not subject to survey and inspection and the buyer accepts the property as is where is. This is a process we're familiar with, for example, in receivers contracts, mortgagee sale contracts and so forth. Clause 7.6 deals with requirements of authorities, that is local authorities, and the issuance of notices. Now this one says that if the notice is issued prior to the contract, the seller must pay for that repair. If it's issued after the date of contract, the buyer must pay for it. Significantly, the failure of the seller to pay for that prior to settlement is not an entitlement for the buyer to terminate the contract. They simply must proceed with the contract and they have their right for damages. This is a good example of a warranty vis-a-vis a condition. 7.7 again deals with the property adversely affected by a list of substantial items. And again, it gives the buyer the right to terminate the contract. Again, when we're preparing a truly unconditional contract for a seller, we'll get our scalpel out and either delete those clauses or change them so far as the law will allow us to do so. But simply crossing them out wouldn't be effective because many of those provisions spring back in as a matter of common law in any event. Those are the important parts of the contract. I've touched on the interest. Clause 9.1 deals with the default under the contract. Traditionally, it only ever dealt with the buyer's default, and the seller has always been able to A, forfeit the deposit, B, sue for damages, or C, affirm the contract and seek specific performance. They've always had that right, and they still do. From a buyer's point of view, note that the forfeiture of a deposit is not the end of your problems. If the buyer resells the property and suffers a loss that's greater than the deposit, he can pursue you for the shortfall. So it's a very major undertaking signing a contract. The contract now includes provisions for the seller's default. Not that sellers default very often, but if they do, the buyer has a right to damages. I think this clause has been inserted because of the recent introduction of the Unfair Contracts Act, because where a contract provides a right to one party and no equivalent right to another, it's often deemed to be unfair. I think this provision has been inserted for that purpose, but I've yet to see it be used. So that concludes my discussion on the standard conditions of the REIQ contract. As I mentioned, the commercial contract is very similar. I'll deal with that in a little more detail in a minute.